Before going into the content, just a thank you to American University for organizing this event. I know we've been somewhat persistent over the past few years to try to get this topic to AU, and I'm hoping that with these great panelists, we can start the conversation on why we need to start talking about private security contracting, military contracting in different parts of the world globally, but particularly in Latin America as well. I'll give you a few statistics, but before then, a very quick introduction of the panelists. You have sort of their bios on the flyer and linked to their profiles on LinkedIn as well. So I'm not going to spend too much time in introducing each person, but simply headline titles. So to my right, Rebecca DeWinter-Schmitt, who is working with the Investor Alliance and effectively is also with American University and also has been advising in the world of private security companies for many years beforehand on certification issues. We have Margaret Ellen Roggensack to my right as well, who is the Executive Director of the Business and Human Rights Lawyers Association, if that's correct, and previously also teaching here at American University and other universities, and has worked in the world of business and human rights and the UNGPs for many years. To my left, I have Inés Echevarría Hayem, who's a specialist with the Organization of American States, looking at security and justice in particular. And last but not least, I have Gary Korn, who's the director, and I've got to get this right because it is a fairly lengthy title, Director of the Technology, Law and Security Program at AU, formerly with the Department of Defense in different capacities, and also Latin America expert. So these four panelists are going to take you through some of the sort of basic issues you need to think about when we're dealing with the world of private security contracting. I'll give you a few numbers, and then we're going to have a bit of a conversation. Each panelist will come in with 5-10 minutes of remarks and comments, and maybe a second round, and then I'll open it up to all of you to ask questions, be it online and or in person. So let's make it as interactive as we can, because I think it's a pretty interesting topic to be discussing today. Why is it interesting to talk about today? I think, Gabrielle, you gave us a couple of stats, but just so you think about numbers for a few seconds outside of law. And the flyer and the presentation for this panel, you had numbers such as the size of the private security globally in a financial sense. So in 2024, it's estimated that the private security sector was valued at approximately $240 billion US. By 2032, it is estimated that it could reach approximately $531 billion. A fairly large economic sector and a quite varied sector as well when it comes to security that's been offered. In 2017, so we are going back a few years, there were approximately 20 million guards supposedly operating globally. I don't believe that's a correct number. Those were potentially the registered guards globally, and I feel that the number could be much higher than the 20 million that was announced in 2017, and certainly growing. In the US, for instance, based on public source data, there are meant to be something like 1.1 million security guards or security personnel working in the US alone. In Latin America, we mentioned something like 2 million security personnel, 2.4 million security personnel. And in different source areas, you have references to potentially something like 16,000 security companies in Latin America alone. Again, I can't test that data, because that's why we're having this panel, because of some of the potential gaps they might be out there in terms of real data. Interestingly, what we could also look like from a revenue perspective, the three biggest security companies in Colombia generated, it would seem, something like $200 million worth of revenue in 2023. And how that's calculated, that's up to the statisticians, but the numbers speak for themselves. And then in terms of the importance of the role that the sector plays, bear in mind that in many countries where you have a large security industry, the security industry in terms of personnel outnumbers systematically law enforcement personnel. Numbers that we have seen, or ratios, supposedly in Brazil, you have for every member of the police, you have 4 security personnel, so a 4-to-1 ratio. Guatemala, 5-to-1. In Honduras, 7-to-1. In South Africa, the police and the armed forces combined are less than the total number of private security companies. Despite the size of the industry, despite the numbers that we're speaking about, despite the evolution of the sector, there is very little known about the private security world. The conversation oftentimes starts and finishes with Blackwater, the Wagner Group, or similar entities. There's very little understanding beyond that as to what the security industry actually represents globally. There's very little understanding outside of the industry itself in terms of the services which are being offered by the security industry. And there's also very little understanding by most persons in terms of the risks, but also benefits associated with the security industry. From an international legal perspective, you won't find any international treaties today dealing with private security contractors. So there is no international legal framework per se to speak of in terms of hard law. But there are other processes and other initiatives and other elements that we can unpack during this panel, which are trying to make a difference. So those are my kind of introductory remarks as to why I believe this conversation needs to be had. And I'm grateful to have these 4 great panelists with me to start unpacking some of these issues, identifying some of the challenges, but also speaking to potentially some of the solutions that may be out there or some of the things that we have to look out for going forward. So I'll stop here, and I'm actually going to turn to you now, Inés, if I may. And from the OAS perspective, speak a little bit, if you may, in terms of what the Organization of American States is doing when it comes to looking at the world of private security. What are the kinds of issues that you're grappling with, but also what steps have been taken, not only by OAS, but also to influence potentially states in Latin America to do a better job in this sector. The floor is yours. I think there'll be a Spanish intervention at this stage, so if you don't have Spanish, go to interpretation. Thank you.
Thank you very much, Jamie. Muy buenos. Muy buenos días a todas y a todos. Es un gusto estar aquí el día de hoy en representación del Departamento de Seguridad Pública de la Organización de los Estados Americanos. Quisiera comenzar agradeciendo a la Academia de Derechos Humanos y Derecho Internacional Humanitario de la American University por recibirnos el día de hoy y brindarnos este espacio para tener esta importante conversación. También quiero reconocer a los organizadores, a nuestro moderador y a mis colegas panelistas por su compromiso con abordar los desafíos, pero también las oportunidades, como vamos a ver, que plantea la seguridad privada desde diferentes ámbitos. Y eso también es un gusto constatar que la diversidad de perspectivas hoy, ¿no? Desde el ámbito de los derechos humanos, del comercio, de la inversión, hasta el ámbito de la seguridad, enriquecerá sin duda este análisis. La OEA reconoce que las empresas de seguridad privada desempeñan un papel cada vez más importante, ¿no? En el panorama de seguridad de la región. Sin embargo, su crecimiento también plantea interrogantes importantes sobre supervisión, sobre rendición de cuentas y sobre derechos humanos. Siguiente slide, por favor. Hoy me gustaría compartir algunas reflexiones desde la perspectiva de la OEA sobre este complejo tema. Para eso estructuraré mi presentación en 3 partes. Primero, daré un breve contexto sobre la seguridad privada en América Latina y el Caribe, su crecimiento, el papel que desempeña y por qué es importante. Posteriormente, analizaré los desafíos de gobernanza que observamos en la región, la fragmentación normativa, los vacíos de supervisión, preocupaciones en materia de derechos humanos, informalidad y también la falta de capacitación adecuada. Siguiente slide, por favor. Y finalmente compartiré el enfoque de la OEA para abordar estos desafíos basándome en las resoluciones de la Asamblea General de la OEA. así como en otras iniciativas regionales que impulsamos para fortalecer la gobernanza y garantizar que la seguridad privada pueda contribuir a la seguridad pública y también al respeto de los derechos humanos. Entonces, espero que esta presentación promueva el diálogo sobre cómo podemos, desde diferentes ámbitos y trincheras, lograr que la seguridad privada desempeñe un papel constructivo, no solo en América Latina y el Caribe, sino a nivel global. Siguiente, por favor. El fenómeno de las empresas de seguridad privada ha crecido exponencialmente en las últimas décadas y su impacto sobre la seguridad, los derechos humanos y el orden democrático requiere una respuesta coordinada, tanto a nivel internacional como regional. Las empresas de seguridad privada, como mencionó Jamie anteriormente, han pasado de ser una industria marginal a convertirse en un sector que mueve miles de millones de dólares. Esta expansión ha dado lugar a una industria más diversificada, con empresas que emplean a miles de personas en diversos sectores. Como pueden ver en pantalla, en América Latina, en algunos países, las empresas de seguridad privada han encontrado un terreno fértil para operar debido a una combinación de factores. Estos son, por ejemplo, la inestabilidad política, altos índices de criminalidad, la debilidad institucional, la presencia del crimen organizado, así como el crecimiento económico prolongado en sectores extractivos que también requieren un tipo de protección especializada. Siguiente, por favor. Respecto al tamaño del sector de seguridad privada, pues en algunos países de la región, como mencionó Jamie también, el número de guardias que realizan estas actividades de seguridad privada supera el número oficial de agentes de seguridad pública, incluso de personal militar, y también ha aumentado el número de armas registradas por estas empresas. Estimaciones indican que el personal de seguridad privada en América Latina asciende a aproximadamente 2 millones de personas. También el número de armas registradas por estas empresas ha aumentado significativamente, lo que plantea interrogantes sobre su control, su almacenamiento y el eventual desvío hacia mercados ilegales. Solo para darles un poco una idea de qué estamos hablando, las empresas de seguridad privada ofrecen una amplia gama de servicios. Puede ser la protección de establecimientos comerciales, infraestructura crítica, puede ser seguridad en transporte de valores, seguridad personal para individuos, apoyo a corporaciones multinacionales y cadenas de suministro en sectores como energía, minería y logística, entre otros. A pesar de su tamaño, este sector es altamente heterogéneo. Mientras que en algunos mercados predominan grandes empresas nacionales o multinacionales, en otros existe una fuerte fragmentación y una presencia significativa de actores informales. Siguiente, por favor. Ahora, ¿cuáles son los beneficios y los riesgos de la expansión de este sector? En muchos contextos, estas compañías han llenado vacíos de seguridad y han trabajado estrechamente con los gobiernos para combatir amenazas a la seguridad pública y proteger recursos estratégicos. Es decir, que cuando operan de manera responsable pueden tener efectos positivos para la población local, para los clientes y para la seguridad en general. También, como consecuencia de esta expansión, la seguridad privada se ha convertido en una fuente importante de empleo en la región. No obstante, también esta rápida expansión ha revelado una brecha significativa en términos de regulación, de supervisión y en ocasiones incluso de respeto a los derechos humanos. En algunos países estas empresas operan en un entorno poco regulado, muchas veces bajo acuerdos privados, lo que dificulta el monitoreo y el control de sus actividades. Algo interesante es que al involucrarse también en la prestación de servicios que en algunos casos tradicionalmente eran responsabilidad del Estado, las empresas de seguridad privada también han generado interrogantes sobre el control del uso de la fuerza, la rendición de cuentas, la gestión de armas y los estándares éticos que rigen la conducta de estas empresas. En ese sentido, si bien hemos visto un avance en normas internacionales y buenas prácticas, pues siguen existiendo desafíos importantes y preocupaciones jurídicas y normativas respecto a su impacto en la seguridad nacional y regional. Entonces, para darles algunos ejemplos, pues algunas preocupaciones pueden ser, por ejemplo, el estatus legal del personal de estas empresas, la responsabilidad individual por conductas indebidas en diferentes jurisdicciones, la obligación de las autoridades de supervisar e investigar las acciones de estas empresas ante posibles irregularidades y su papel en conflictos armados, entre otros. Siguiente, por favor. En cuanto a los principales desafíos del sector, me gustaría enumerar 4 de los principales desafíos. En primer lugar, uno de los principales riesgos asociados a este sector son el uso de armas de fuego. Muchas empresas manejan arsenales significativos y, sin embargo, los sistemas para el registro, almacenamiento y seguimiento de estas armas suelen ser deficientes. Existe escasa información pública, falta de control de inventarios y ausencia de procedimientos estandarizados. Esto facilita el desvío de armas, así como el uso indebido de la fuerza, con implicaciones serias tanto para la seguridad pública como para el respeto a los derechos humanos. Otro gran desafío en la región son las brechas en los marcos regulatorios. Aunque la mayoría de los países sí cuenta con marcos regulatorios específicos para este sector, estos suelen estar desactualizados o ser insuficientes para enfrentar este fenómeno eficazmente. Por ejemplo, muchos de ellos se enfocan en el otorgamiento inicial de licencias, pero no en la supervisión continua de estas operaciones. Además, los organismos reguladores también suelen tener insuficientes recursos, falta de personal, capacitación y herramientas tecnológicas, lo que también limita su capacidad de monitoreo. Esto se agrava también con una fragmentación institucional. Es decir, que en muchos países las competencias están repartidas entre varios ministerios o agencias que no siempre comunican entre sí. Por ejemplo, la regulación de armas puede estar en manos de una entidad distinta a la que otorga las licencias de operación de estas empresas. Esta falta de coordinación debilita los mecanismos de gobernanza y facilita que ciertas prácticas irregulares pasen desapercibidas. Un cuarto punto que quisiera destacar es la formación del personal de seguridad privada, que en muchos casos no se implementan cursos de capacitación o estos son cortos o no abordan adecuadamente los estándares internacionales de derechos humanos, de derecho internacional humanitario y no preparan adecuadamente al personal para manejar situaciones complejas donde el uso de la fuerza debe ser proporcional y excepcional. Siguiente, por favor. Entonces, para garantizar la prestación responsable de servicios de seguridad privada, especialmente en entornos complejos, es fundamental que los gobiernos, las organizaciones internacionales, la sociedad civil y las propias empresas fortalezcan las regulaciones nacionales que rigen sus actividades y mejoren la debida diligencia en la cadena de suministro de seguridad. Entonces, a nivel internacional, instrumentos como el documento de Montreux y el Código Internacional de Conducta buscan establecer normas y buenas prácticas para la operación de estas empresas, garantizando el respeto de los derechos humanos y del derecho internacional humanitario. Siguiente, por favor. Ahora me gustaría hablar del papel que desempeña la OEA en este ámbito. Desde la OEA estamos convencidos que para avanzar en una gobernanza efectiva del sector de seguridad es necesario adoptar un enfoque multiactor que incluya a los estados, al sector privado y a la sociedad civil para asegurar que las empresas operen de manera responsable y conforme a los estándares internacionales. Este enfoque es especialmente importante en América Latina y el Caribe, donde la colaboración con los estados es indispensable para garantizar que estas empresas no solo respeten los derechos humanos, sino que también estén debidamente integradas, reguladas, supervisadas como parte del ecosistema de seguridad pública. Por eso, en este marco, la OEA busca contribuir al fortalecimiento de los marcos regulatorios nacionales para mejorar la gobernanza, el control y la transparencia de las actividades de estas empresas en la región. Siguiente, por favor. A lo largo de los años, diversas resoluciones de la Asamblea General han abordado expresamente el papel de las empresas militares y de seguridad privada en la región, así como los múltiples desafíos que enfrentan los estados en la regulación de estas empresas. Estas resoluciones es muy interesante porque efectivamente reflejan la creciente atención que recibe la seguridad pública en la agenda hemisférica. Algunas de estas resoluciones encomiendan al Departamento de Seguridad Pública la elaboración de una ley modelo de carácter voluntario o también promueven estudios para realizar el impacto de este sector. Otras destacan la necesidad de respetar los derechos humanos y el derecho internacional humanitario y piden examinar riesgos como el posible desvío de armas por parte de estas empresas. En este contexto, la OEA impulsa 3 líneas estratégicas de acción. Siguiente, por favor. Primero, buscamos promover la adhesión de los Estados miembros al documento de Montreux y al Código Internacional de Conducta, y buscamos fomentar la implementación de normas y buenas prácticas contenidas en ambos con el objetivo de elevar los estándares regulatorios del sector en la región. Segundo, apoyamos el fortalecimiento de los marcos normativos nacionales en los Estados miembros para poder regular eficazmente las actividades de estas empresas, asegurando mecanismos de supervisión adecuados, transparencia, rendición de cuenta y cumplimiento de los estándares internacionales. Aquí me gustaría agregar que de manera general, reforzar el Estado de Derecho y la estructura institucional tiene un impacto positivo y reduce el margen de operación de empresas ilegales o informales. Y tercero, también fomentar la cooperación internacional mediante espacios de sensibilización y de diálogo. La colaboración entre estados, organismos regionales e internacionales es esencial para establecer marcos regulatorios armonizados e intercambiar buenas prácticas. Por último, me gustaría ilustrar esto con un ejemplo concreto. La Conferencia Regional sobre Seguridad Privada, que se organizó en marzo pasado junto con AICOCA y el Ministerio de Gobernación de Guatemala. Esta conferencia estuvo alineada con los mandatos de la Asamblea General de la OEA y representó un hito en el impulso hacia una regulación más robusta y responsable del sector. ¿Qué buscamos hacer? Reunir a representantes gubernamentales, a empresas, a sociedad civil y a la academia para intercambiar experiencias y examinar juntos estos desafíos y soluciones. Como pueden ver en pantalla, esta conferencia incluyó varios paneles sobre diversos temas, así como mesas sectoriales con compromisos operativos orientados a mejorar la gobernanza y la seguridad del sector. Siguiente, por favor. Creo que sin duda nuestra presencia aquí el de hoy refleja un compromiso común, que es de apoyar desde diversas perspectivas a los estados en el fortalecimiento de estos marcos normativos para que las empresas de seguridad privada puedan tener un papel positivo, constructivo en la región, en apego a los estándares de derechos humanos y derecho internacional humanitario. Desde la OEA reiteramos nuestra convicción de que la seguridad, para ser efectiva y legítima, debe construirse sobre la base del Estado de Derecho, la transparencia y la colaboración. Muchas gracias por su atención y en nombre de la OEA, pues reafirmo nuestra disposición a seguir trabajando en estos temas. Muchas gracias.
Thank you very much. In 15 minutes, you covered a huge amount. I was taking as many notes as I could, so it's wonderful to hear. So I think you raised many issues. I'm not going to try and summarize them, and I'll come to you in a second. But clearly, I think from the OAS perspective, you've identified obvious gaps that can be replicated in many other parts of the world in terms of you recognize that the fact that private security contractors are major actors in many locations in Latin America, that they're seen as positive vectors in the sense that they're there to help supplement where there are gaps in law enforcement, that they are used not only in terms of potentially protection of the public, but you mentioned a lot about clients as well, multinational corporations, which will be relevant to the next section. But worryingly, you did also note the lack of regulations, the lack of, let's say, coherence across different sort of jurisdictions in terms of how to manage security contractors. And that lack of regulation with the lack of accountability could also have, greater concerns. As you mentioned, many of these security contractors do have weapons and are armed. And so there's a whole question of weapons management, storage of weapons, and trade of illicit weapons in Latin America. So that picture is a very bleak picture in a sense of what can go wrong potentially, but a positive in terms of the fact that OAS is now taking this on as a key sort of area to focus on and coming up with resolutions. Now, for those who haven't seen my background, I'm the executive director of ICOCA, so thank you very much for putting ICOCA in your presentation. I didn't ask for that, but it's excellent to see exactly that level of cooperation between regional organizations and organizations such as mine, which are multi-stakeholder, to try to work on these issues. I'd like to recognize representatives from both Switzerland and the US in the room who are also member governments of the association in that regard. So I'm going to pause here. We've given us a framework, lack of regulations, but the utility and use and presence of security contractors in Latin America. So I'm going to turn to you, Meg, if I may now. We spoke a lot here about human rights. We mentioned guiding principles, and we came up a lot with questions of clients. And by clients, we need to bear in mind that in most parts of the world, clients are diverse. They're not simply limited to a few government contracts. Clients can be anyone who basically hires and uses security companies. I've used security companies for my premises in parts of when I was in Kenya or in South Africa, for instance. Humanitarian organizations use security companies. Multinational corporations use security companies. And it raises questions about risks within supply chains as well, because ultimately you need to ask yourself the question, if you have a service provider somewhere in the supply chain that's unregulated, what does that mean about the whole credibility of the supply chain? So Meg, you bring a perspective which is actually working with the clients and working with the law firms that advise the clients about compliance and risk. And in your, I think, previous sort of career, you also work closely with the Voluntary Principles Initiative on Security and Human Rights on issues linked to the extractive sector and what they do on security. So rebounding off my earlier comments by Inés's great presentation as well, can you bring your kind of perspectives to this conversation on clients, security, what needs to be done, any gaps, any ideas, or any kind of examples you may have?
Great.
Thank you.
Thanks. I think that's right. Thanks so much, Jamie, and thanks to the Institute for sponsoring this conversation. It's really great to see effectively a packed room for this conversation because it is an issue that, as Jamie has said, passionately deserves more attention, and one that, as I think Inés outlined, is, it's a major industry, major driver, and depending on what how governments approach this task, either for good or for ill. There are plenty of risks in this sector. Jamie asked me to reflect on how this all impacts clients of private security contractors. And I wanted to just really address 3 points. First, how major companies are connected to private security contractors and what that might mean, what might be some of the risks from their perspective, and then also what might be the legal and regulatory potential exposure as a result of that. And so starting from the top, in general, business can be connected to private security contractors in one of a number of ways, either directly through their own operations, through joint venture partners, or through their supply chain. They might be buying some component or some product or some raw material in the supply chain that has been obtained through arrangements that involve security. And most often, we're talking really about extractive, the new energy sectors, new minerals used to power the energy transition, and agribusiness. Those are the industries that have the highest risk of potential exposure to private security. But as I've mentioned, it could involve even a generic manufacturer of a product that has got some component or commodity in their wider supply chain. And the risks are at one level pretty evident. Where private security is being utilized, of course, there's a risk of loss of life, but more immediately in many contexts, if you think about it, if you think about these types of operations, the categories of risk relate to how are employees obtained for this particular project. Often there might be a forced labor component to recruiting and then also retaining those workers on site. There can also be gender-based violence associated with that, and of course, human trafficking risks, the loss of life related to the use of security in a way that is not consistent with humanitarian and human rights legal principles. Other risks might be related to the impacts on communities, affected communities, whether or not they have been consulted about these operations. Again, there could be a mix of public and private security. I see a number of students from my class. We talked a lot about the social license to operate. if these companies have a concession from a government, but not really the consent of the community, and public and private security are there in effect to enable this operation to continue, there can be ongoing risks to the community, as well as the operating risks that relate to use of resources, degradation of those resources, impacts for loss of biodiversity, et cetera. So all of those things can translate into violence or, low level but ongoing conflict that can implicate both public and private security. 10, 15 years ago, the conversation would have looked a little bit different, because at that time, the main exposure for companies would probably be mostly reputational. There would be some litigation risk, but the scope for litigation, at least here and other parts of the world at that time, had narrowed fairly significantly. These types of litigations were long-winded. And again, I'm talking about broad litigation, not litigation focused on PSCs, which is another story. But the UN has brokered, as Jamie mentioned, a conversation over the past 15 years to better delineate how international human rights law applies to the respective roles and responsibilities of governments and companies. And the UN Guiding Principles, which issued in 2011 and have been unanimously adopted as essentially a global standard, really help clarify the respective responsibilities of governments on the one hand, both home governments of these companies and the host governments, to properly regulate these industries, but then on the part of companies to respect human rights and to, in effect, know and know what the impacts of their operations are and show that they are taking meaningful steps to address them through a process of due diligence that can include risk assessment. And then finally, in both cases, to remediate those impacts. So just briefly to delineate, what does that mean in the context of this particular issue? The UN Guiding Principles were a toolkit. They were a set of principles that could then be flexibly adapted to a variety of industries, including the security industry itself. But at this higher level, really initiated and sparked a number of efforts on the parts of governments, but also industry in collaboration with other stakeholders to better delineate the relationship between international human rights law and specific standards for given business sectors and human rights risks, code of conduct, social audits, et cetera, different ways of identifying and managing that risk. Although those initiatives were really not a substitute for harder edged approaches, which have started to emerge. And so over the past several years, particularly in Europe, there have been a number of measures adopted to require companies to both report and also to conduct both human rights and environmental due diligence related to their operations. So again, going back to where I started, if they have private security at some place in their supply chain, they're expected to know that, and they're expected to know what that means. For example, are these private security providers certified? Are they members of ICOCA or not? Is the operating environment one that has a robust regulatory environment? Very often, probably not. Is the environment prone to conflict? If so, further heightened challenges and risks. And companies are expected now to be aware of that and to be taking steps to address that. And although there is an ongoing and very lively debate in Europe about the implementation of these measures and whether or not they've been a bit too far too fast, I think everybody understands that the expectations on business broadly here are going to be to examine and account for those uses. In the US, I just wanted to flag two measures that are very important. One, Section 307 of the tariff law of 1930. We've all heard a lot about tariffs in the past year. This law, again, comes from 1930, but it prevented the import of products made with forced or child labor. However, there was a big exception that swallowed the rule, which said that if we didn't have enough of that product made in the US, then it could be imported. That loophole closed in 2016, and the US is aggressively enforcing it now. And so any product that comes in with potential forced labor associated with this production is banned from being entered into U.S. stream of commerce. And that's a pretty compelling sanction. And I mention this because, again, going back to where I started, if a company is mining, extracting, processing raw materials, commodities, and there is use of private security that may raise forced labor issues, now you've got a problem in the U.S. Your product can't come in, it can't be traded. There's a separate provision, the Uyghur Forced Labor Act, that implicates China directly. It includes a rebuttable presumption that products made in a particular region of China where there has been a pattern of genocide against Muslim population are presumed to be made with forced labor. That's a different paradigm, but it's important because it shows that even though the U.S. does not have a generic law requiring corporate human rights due diligence, the forced labor bans have real teeth. I finally just wanted to mention that in addition to the broad due diligence and reporting rules in the European Union, there are specific sector regulations that equally pertain to the issues we're discussing. One on deforestation, another on batteries that includes critical minerals, and then a third on forced labor. And just to zero in on the deforestation regulation, it will go into effect at the end of this year and includes a range of commodities. And virtually every one of these has raised issues around safety and security of local communities. Wood, obviously, commodities like cocoa, coffee, palm oil, that are also very controversial. Companies are required to know who is providing those products and to certify ultimately they've not been produced in such a way as to be associated with deforestation. And again, because deforestation operations and relatedly land grabs often can be associated with the abuse of private security at a local level, companies that are sourcing those commodities directly or indirectly have to be mindful of the circumstances under which security is being provided to those operations. So I do think that the attention on the private security sector is long overdue. ICOCA is a very valuable platform for companies to learn more about this industry and the challenges and risks, but also ways to identify and manage that risk. So I'll stop there.
Thank you very much, Meg, for that. It may sound, when we speak about European legislation, far removed, but I think the point that you were underscoring there was, if you're a European corporation with a supply chain that extends all the way to Latin America, then the activities of that European corporation, the multinational corporation, will be scrutinized even in Latin America. So if it's using local suppliers, if it's sourcing from certain producers, then, and if we have bad security practices in that particular location in Brazil or Chile or wherever the case may be, then there's a potential for that multinational corporation that has nothing to do with, let's say, being based in Latin America, but operating out of or integrated in the European Union instead, will be caught up by European legislation and may be held responsible for activities which are so far removed from its headquarters, so far down supply chain in Latin America, that could also be a kind of a stirring or a frightful situation for, let's say, the corporate folk, the lawyers out there, the compliance teams, to say, how do we track every aspect of our supply chain? How can we be sure that every supplier, including security companies, are properly listed in our supply chain, because they may be a risk that goes with it. So multinationals, businesses will have to think about that, especially where they're sourcing. And you mentioned some of the high-risk sectors, but agribusiness is not necessarily high risk, but it is a sector where you can have those issues. So we have the businesses. And then you may ask yourselves, why are we speaking about investors? So Rebecca's, you're the Associate Director of the Investors Alliance for Human Rights, right? And quite often people think investors and human rights, actually, they don't seem to come together. But in actual fact, you have proven a case that they do. Now, why do we want to speak about investors? Just a quick couple of examples, and then I'm going to turn it to you, because in my mind, the investors are part of that broader kind of supply chain question. In 2020, I think it was, November 2020, a French supermarket chain, Carrefour, had that's your example. Okay, you keep it, right? That's your example, right? So you keep that one. Another example. Escobal?
No.
No, okay, all right. Guatemala, major extractive firm with local ownership, major security issues. Yes, big human rights issues, security concerns, and an impact on the local communities. But the headline news was the value of the stock price of that company went from, let's say, $50 per share, crashed down to about $10 per share. I don't have the exact numbers in front of me. So there's also a financial hit on the company because of security issues. But at the same time, there's also responsibility for the investors to think about how they manage these situations and these risks. So as you have the example, I'll give it back to you. Tell us a little bit, why should we care about investors and why should investors care about this kind of conversation?
So you can hear me? Yeah, right. Okay. Well, first of all, thank you. Thanks for that introduction, and thank you to the Academy for inviting us here today. Really glad to see such an interested audience. I'm going to do three things. Briefly, I'm going to tell you who the Investor Alliance for Human Rights is, because admittedly, not all investors care equally about human rights issues, but we certainly work with investors who do. And I'm going to tell you a little bit about how investors can be connected to human rights impacts. Jamie already laid some of that groundwork. Then I want to talk to you a little bit, and Meg touched on this, about what kind of expectations we have of investors under international business and human rights frameworks. And then thirdly, I'm going to talk about what particular kind of leverage investors can exercise over their portfolio companies to try to push them to demonstrate better human rights performance, to include in relation to the use of private security. So just briefly, who's the Investor Alliance? We are nearly 250 institutional investors, think asset managers, pension funds, endowments, university funds, who have self-identified in many ways as investors who seek to invest in a responsible, sustainable fashion, often what's referred to as ESG investing, which is a shorthand for environmental, social, and governance. And we do three things with those investors. We try to build their capacity to understand what types of human rights responsibilities they have throughout the investment life cycle and to help them execute those responsibilities. Second, we work with the investors collectively to use their collective voice to push portfolio companies to improve their performance across a whole range of sectors, to include agriculture, extractives, and others, all sectors utilizing private security, although I don't think there isn't a sector that doesn't utilize private security, quite frankly. And then thirdly, to also capacity building, investor engagement. Oh yeah, policy, what Meg spoke to. Very much to have investors use their collective leverage to weigh positively on relevant standard setting policy developments that are relevant to creating an enabling environment for investors and companies to respect human rights. So that's where I come from. Self-selective bunch, admittedly, but nevertheless, one that includes some very large asset managers and asset owners. So how are investors connected to human rights impacts? So there's really two ways. There's the kind of very direct, it's a publicly traded private security provider, PSP for short, and investors have bought shares in that company, right? And think of a good example of that being like G4S, which I believe is currently the largest private security provider in the world, if I'm not mistaken, maybe. Okay, but big, but very big, definitively. And so in that case, investors will hold shares of G4S, and if G4S commits some type of human rights abuses, which can happen and which has happened, it can pose a direct risk to the investor. In fact, the investor can be seen as contributing to that risk because the investor directly is a partial owner in that company. And this has, of course, potential financial repercussions for the investors, reputational repercussions as well, because they're viewed as an owner and have a responsibility as an owner. And frankly, it can also lead to situations where investors say, okay, that's just too risky for me. I'm going to divest or exclude this company from my portfolios. And that happened, for example, with G4S in 2019, where NBIM, that's the Norges bank asset management arm of, basically manages all of the Norwegian pension funds money. And they decided, because of abusive human rights conditions towards guards in Qatar and UAE, a situation that amounted to basically I would say bondage labor, right? I mean, they seized passports, didn't let workers leave their jobs, lied about work conditions, excessive overtime, et cetera. And so that led them to decide that they were going to exclude the company from all Swedish pension funds. You see there a direct link between ownership in the company and risk to the investor. But frankly, in the private security industry, you have a lot of privately held companies and not always publicly traded ones. So here's where you have a bit more of an extenuated relationship between the investor and the private security provider. And in the middle there sits the portfolio company that's utilizing the private security. So what you have there is a situation where the investment company can be directly linked through the portfolio company to ultimately the private security provider. Now, that doesn't mean that there's not risk involved, right? Because as Jamie was starting to point out, in certain situations, what you'll have is because of the abuses that the private security provider is implicated in, that is going to have an effect upon the client, the company itself that's utilizing that security, right? And here, we know, and Jamie started telling an example of in Brazil, and okay, actually, we got it from a report we both worked on together, which unfortunately I was going to bring a copy of. I'll talk about that in a second. But so it was Carrefour. There was a security company that was hired, and I'm going to hurry up. I see the time too. There was just a man, I guess. I don't know exactly what he had done, quite frankly, but he was beaten to death. And this had tremendous repercussions for Carrefour. So their share price dropped 6%. In addition to that, the Brazilian government levied a fine of, I think it was the equivalent of 20 million US dollars. And so this was a tremendous financial hit to Carrefour, which of course for investors, if you just want to focus on the financial kind of responsibilities that investors have, that meant a short-term, immediate drop in share prices, but also potentially a longer-term impact on the valuation of the company. So why am I paying this out? Because there's many ways that investors are going to be connected. And if you think about the international business and human rights frameworks like the UN Guiding Principles on Business and Human Rights, which Meg just mentioned, there's something embedded in there because we talked about the responsibilities, right? All companies and investors need to have a human rights commitment to respect human rights throughout their investment and business activities, number one. Number two, all required to do that, what Meg called knowing and showing, undertaking due diligence. How are my investment activities, how are my business activities affecting human rights? And then number three, when those issues are identified, to provide some form of remediation, right? And so embedded in that is something called the involvement framework. That is how we conceptualize the link between a for-profit company and a human rights harm. And that goes from everything from causing, for example, a security company that beat the man to death is in a causation position, to contributing, right? So for example, through the fact that an investment firm owns a share in a private, in a company that then hires a security provider, there you have a kind of more tenuous kind of like direct linkage situation. But and usually that's what investors are in, a direct linkage situation, right? They're not the ones hiring the private security company directly, and they own it, or even, through this relationship with the portfolio company. But however, according to these frameworks, if an investor is aware of this fact, if I hold shares, let's say in Carrefour, and I find out that they have guards that are, using excessive violence to the point that someone's dying, I then have a responsibility to use my leverage as an investor on Carrefour, to press Carrefour to understand better and deal with what his private security provider is doing. So investors are in this interesting position. If I don't do that, by the way, I move from a position of being directly linked to that harm to actually considered to be contributing to that harm. So that's that involvement framework: cause, contribute, direct linkage. And it's a fluid framework. Why am I saying all this? Because investors need to be very aware how they're using their leverage, either as a direct owner in a private security company or as a, tied through a portfolio company that utilizes private security. They need to be aware how they can exercise their quote unquote leverage to make sure that ultimately at the end of the day, that private security provider is not engaging in activities that lead to human rights harms, right? Now, so what can investors do? Right? Investors usually hold hundreds, or thousands of companies, and their shares in a company may amount to what, 2, 3, 4%, and that'd be a lot. Actually, it's usually far less than that, frankly. So what do investors need to do? Investors need to work in organizations like ours, collectively, for example, to raise their voices together. So, I might not be the only one holding Carrefour. Perhaps there's 3 or 4 other of my colleagues in an organization like the Investor Alliance that do. We come together, we try to engage with that company in a dialogue, right? To understand what they're doing. What are your policies? What are your processes? What are the remedial measures are you going to take now that you know that your private security provider was involved in this? Are you contributing to remediation of that harm? That's one thing they can do. Another thing that they can do is, if there's legislation that's being discussed, like much of that which was talked about here today, like for example, in the EU, making sure that there's explicitly provisions in laws around disclosures, due diligence, that require also due diligence on private security providers, right? And Furthermore, they can ask their portfolio companies, you know what, are you using private security providers that are actually members of the International Code of Conduct Association, Jamie's organization? Because we know that this organization makes sure that private security companies are actually doing what they need to do to understand what their impacts are on people and communities. So this is just a handful of some of the things they can do, you know, of course, also exiting, frankly, but that's a kind of last resort oftentimes, because better to use your leverage to improve conditions than just to, you know, cut and run. I'm going to stop there just to maybe like set up a question for me should someone want to ask this okay, so will investors have the data they need to understand what a good private security provider is, or if a company's using that private security provider responsibly? No, but I can tell more later. So
Thank you very much, Rebecca. So we're covering a lot here. So if any of you have stocks and investments, from now on, think about security as well, because there could be an impact on you. You could also have a level of leverage, but it's something that investors need to consider as well. It builds on what you're saying, Meg, with regard to the multinational corporations, and it builds on the questions linked to kind of regulations and the risks that go with it. So we've presented so far a very simple face of security and the risks that go with it and the issues. I can guarantee that most of you in the room, when we've been thinking about security, have been seeing security through the lens of someone in a uniform standing outside a facility with a truncheon. Simple as that. That's what security looks like. Well, Gary here is actually going to challenge that perception that you have of security and to add another layer of complexity to the conversation in terms of what does private security potentially look like today, or where could it go with the introduction of technology. And that will have an impact on the regulators, it'll have an impact on the investors, it's going to have an impact on the clients in terms of what they do. So Gary, I want to say last but not least, because we're going to come back to you again afterwards, technology, private security. Can you educate us on that?
I can take a shot at it. It's hard. And it's hard to top the prior panelists' presentations, especially, I mean, it was an excellent lay down, Inés, of the challenges in this space. And I'm listening to it, and it's making me think about, one, regulation of what? What do we mean by security? What do we mean by technology? So let me come back to that in a second, but I mentioned this to some of our colleagues on our prep call. Probably more than 20 years ago or so, my father-in-law, who lives in a neighborhood of Rio de Janeiro, asked my wife to help him. She's also an attorney, and to get some information about how in the U.S. Law enforcement personnel can be contracted in their private capacity to provide security services. And he was asking this because he was helping figure out for the gated community that they live in Baja and in Rio, to have private security for that community. And I mean, ever since I've been going there for more than 30 years, right? There's guards there, there's a gate at the front. Advance that picture, and today, if I go there, in order to get into the community, I have to stop. I have to have my face photographed. They're taking biometrics. They're comparing to see if I'm on an access list, et cetera. So they're collecting all sorts of data about me and maintaining that data. That's a new element of the security service that they've been providing for a very long time. All is just take it a step back a little bit. It's one of the basic precepts of the Westphalian Order was the monopolization of the use of coercion and force in the state for security purposes. And what we've seen, it's not necessarily new. We've seen an acceleration, I would say, of privatization of this, of outsourcing of this responsibility. And in fact, as another example, I think the existence of ICOCA is tied to things that happened in Iraq, where the U.S. government and others were now trying to reduce the footprint of full-time service members and outsourcing some of those responsibilities to private security companies, that we're getting further away from the regulatory structures that are built around managing government activities, around managing how the governments exercise that monopoly over force, et cetera, right? Now you introduce technologies, and technology itself, let's start with a baselining. You can look up different definitions, but essentially the application of scientific knowledge to the practical aims of human life, right? When a security firm transitions from using the horse to a motor vehicle to provide mobility in the provision of security, it's introducing a new technology. We don't think about it. We get inured to some technologies until there's a new one that bursts on the scene, like artificial intelligence and all the other ones that are sort of in the fore of our thinking these days. And each time you introduce a technology, you are advancing the efficiency or the efficacy, the ability of that human function, right? And expanding possibilities at times. Now you could think about this in a range of areas. Surveillance. If you're going to provide security, I go back to my many years in the military and I think about it as security operations. You start at a basic framework, a cycle of observing to collect and understand the environment that you have to secure or protect or operate in, orienting to that, deciding on an action, acting, and starting all over again to reevaluate. Well, that observe point now, there's all sorts of technologies like the biometrics that I mentioned earlier that can be used to collect all sorts of information and data to inform security decisions. In some ways, that's good. It provides you more informed decisions. In other ways, it implicates privacy. It implicates potential impacts on free expression and et cetera, that are now, again, in an area that's getting further from the regulatory frameworks meant to control government action in those spaces, and it's more outsourced. And I think that's where you see this stripping away. Things are getting both in terms of the scope and scale, Jamie, that you mentioned at the beginning, and the number of security contracting firms, et cetera. But as part of that too is how do we define security and security contracting companies? So I thought it was interesting, Rebecca, you're talking about the due diligence and whether the companies or the investors are really have the capacity to do it. Well, I mean, I've been advising companies and seeing some new things come online now where using artificial intelligence and big data, et cetera, to do due diligence is both amazing and frightening. I watched a few use cases where the amount of information that these companies can put together about any one of us to get a full spectrum picture of who you are, what your connections are, right? All these things, which goes into due diligence. But at the same time, you're having the question of what's the framework for that? How much data should they be collecting? For what purposes? How long should they be maintaining that data? Should they have to, delete it off? These are frameworks that I'm, very familiar with in terms of government operations. They're not nearly as clear when it comes to the private sector, right? And so, part of this is understanding what that regulatory space is like. The other, you can talk about cybersecurity. Now there's a never-ending a number of companies out there, the CrowdStrikes, the Mandiants, you name them, that are all providing security services in the digital realm and in cyber. Is that a private security contracting company? Do we look at that in the same way as the guards with guns, or is it something fundamentally different? Right? These are, I think, all sorts of questions that get implicated by this, and you can pick a technology that in the public zeitgeist. You can think about drones. I can guarantee you that security companies are using drone technology to be able to extend their ability, their reach, to see the environment around them, to identify potential threats that they're charged with protecting against, et cetera. The AI decision-making and all the risks that come, there are speed benefits, there are other things, but the risks that come with, is the AI trustworthy in the way it's enabling decision-making by a human, or at what point is the decision-making actually being taken by a computational system? Are there biases built into that? Are all these questions that states are wrestling with generally for their use as a state? And I think you're way out on the periphery when you're talking about using these capabilities for private security purposes. So, I think, all this just begs a number of questions about exactly how we think about, as you're going to try and catch up with the privatization of the security function generally, and the expanded ability for private actors to do a broader set of activities in support of security. How are you factoring in all these new technologies, how they're being used, and how you're going to extend regulatory frameworks to your earlier points, right, and the OAS focus to all of these? So I'll just stop there and we could take questions on those.
Thank you very much, Gary. I'm going to open up to the floor. We have a few extra minutes because we started late. So I've been told we can go on to about 10 past, a quarter past. And so I'm going to pass it over to you for any potential questions that you have. I think the points that you mentioned there, so the example of the sort of the gated community. Think next time you walk into a major building somewhere when you go back home in Latin America and you have your CCTV cameras inside the facility scanning your private movements as you go in through the lobby of the building, and ask yourself who's actually gathering that information and how is it being used. Now, in most democratic societies where there's no sort of questions when it comes to sort of potential misuse of that information, the regulations should be fairly tight, or at least the control will be fairly solid in that regard. But if you go to more high-risk environments in different parts of the world, including Latin America, where I think you mentioned Inés in terms of ownership, in terms of profiles, in terms of who's actually in those security companies, then you have a potential, some of the security companies being close to certain government regimes or agencies who are not necessarily respecting the rule of law. And so they may now have access to data and information on individuals or other technologies which could be misused in a way which would be undermining the rights of individuals, of yourselves and others. And it's all in the hands of the private security contractors. And you mentioned drones. Yes, I mean, for my work, there are drones being used by security contractors left, right, center, because it's a question of efficiencies. It's about having greater access to the concession you want to site. Rather than having someone walk the perimeter or drive around the perimeter, you use a drone. But if you're in a situation where you have an extractive site, for instance, or and you have human rights defenders or environmental issues and villages being moved out, a drone going up and down the perimeter can have negative consequences on those individuals, on those local communities. I know full well that if a drone is flying above my garden, I have every wish to shoot down that drone, but I don't carry a weapon. We don't do that in Switzerland. But it is an invasion of privacy as well. So we'll hopefully come back to technology as well. And it's fluid because we don't quite know where it's going to take us going forward. I'll pause over here and maybe now push it out to all of you. And if there's anyone online, for any questions that you may have. Ideally, you have 1, 2, maybe 3. I'll take 3 questions and you can direct them to anyone or everyone. I'll ask for short questions and shortish answers so we can get through as many as we can if we have a few.
Let's do 2 in person because we have a couple online. So 2 in person, so 1 over there and 1 over here.
Hi, thank you for this panel. My name is Daisy Paredes. I'm currently working here as a research assistant at WCL. I think one aspect important of this topic in Latin America is power imbalance that leaves community in greater vulnerability. For example, the Escobar case that was mentioned this mine that was run by a Canadian company who hired a local firm that was affiliated with the Israeli Golan Group, and they committed violations against indigenous communities that were protesting for environmental and land rights. So bear in mind this power imbalance, and that many countries in the region might not be willing or able to hold accountable these companies. What mechanisms do you think should be in place or should be used to hold accountable not only the private companies that are, the private security companies, but also these transnational companies that come to the region and hire these companies when they are so powerful, or even when it comes to technology that the region is even starting to grasp what this technology means, especially when the principles of due diligence are mostly soft law instruments. Thank you.
Second question.
Hola, ¿qué tal? Ay, no puedo escucharme y escucharlos. Sí, se me ocurrió pensar qué regulación existe o si hay alguna indicación puntual sobre el manejo de la información privada que este tipo de empresas tiene acceso, puede adquirir y puede documentar. Porque el dron que sobrevuela por mi casa logra obtener material de mi vida privada. El que me pide el ingreso en el country obtiene mis documentos, obtiene mis datos de filiación, obtiene mi foto. Hay un uso de la información ahí o una posibilidad de uso de la información que yo considero que debería ser regulado.
Next question, it's online. It's in Spanish, so keep the translation on. Sobre los desafíos éticos y legales, en muchos países, incluidos Ecuador y Colombia, las empresas de seguridad privada operan cerca de zonas en conflicto social o étnico. ¿Qué mecanismos recomienda la OEA o los panelistas para prevenir violaciones de derechos humanos y asegurar el respeto al uso progresivo de la fuerza? Pregunta de Camila Isabel Moreira, desde Ecuador.
Thank you. I'm so glad to be the moderator for those. Any volunteers? We have a question about issues of accountability. We have a question with regards, and there's references to technology as well. We have references or a question about the management of data, private information, and what that looks like. And we have a question about the ethical and legal challenges in the kind of more high-risk environments, which I think OAS was specifically mentioned in that translation. So maybe last question first to you, maybe Inés first for the answer, and then volunteers for the others, as well as you, Gary. Maybe I'll take as well.
Considerando que las preguntas se hicieron en español, contestaré en español. Sí, primero un poco sobre este tema quería reaccionar a la presentación de Gary, porque creo que mencionó dos puntos que me parecen muy importantes, que creo que también pueden aportar a esta conversación. Sobre este ejemplo que dio de esta comunidad cerrada, creo que un punto importante también es que la expansión de este sector de seguridad privada también ha acentuado de cierta forma la desigualdad y el acceso a la seguridad. Entonces la pregunta también en ciertos casos es quién puede pagar por la seguridad, y que muchas veces hay personas que dependen exclusivamente del Estado contra otras que pueden tener este acceso, que es un tema también que se ha abordado mucho y que me parece interesante. Y también reaccionando un poco a lo que mencionó, pues sí, efectivamente, al operar con sistemas, digamos, de vigilancia electrónica, se plantea mucho la cuestión sobre el manejo de información sensible por estas empresas sin estar sujetas a estándares claros de protección de datos, ¿no? Lo que, por supuesto, puede llevar a una vulneración de la privacidad y los derechos de los ciudadanos. Bueno, pues respondiendo un poco a las preguntas, primero sobre qué pueden hacer, qué se puede hacer para que haya más voluntad política y que no sea solo, digamos, soft law, sino marcos regulatorios pues más firmes, pues es justamente lo que estamos haciendo desde la OEA, que estamos promoviendo la adhesión a ciertos instrumentos y no solo eso, sino que también proveer asistencia técnica para mejorar las leyes que ya existen, para actualizarlas o simplemente para crear nuevas leyes. Entonces, eso es muy útil ya que pues son realmente leyes que son adoptadas a nivel nacional. Pensamos también que es importante que haya más diálogo en el ámbito regional para que pueda también, por supuesto, haber cierta armonización y coherencia entre los diversos estados. Y en cuanto al uso de la fuerza, pues creo que es un tema también muy vinculado. De hecho, también es un tema con el que se trabaja mucho desde la OEA. Tanto damos cursos a diversos actores sobre uso de la fuerza. Esto lo hacemos también de forma en estrecha colaboración con la Comisión Interamericana de Derechos Humanos. Se han hecho varias iniciativas para justamente trabajar en todos estos ámbitos. Y pues también contestando a la última pregunta, pues también desde la OEA tratamos de tener una mirada integral. Entonces no es solo seguridad privada, sino también con una mirada de género, de derechos humanos y también, por supuesto, tomando en cuenta ciertos grupos con particularmente vulnerables, ¿no? Como se mencionó en la pregunta, con las comunidades indígenas, siempre tratando de tener este enfoque multiactor, que no sea solo con los Estados miembros, sino involucrar a la academia, organizaciones internacionales. Y es un poco lo que se buscó en el evento con ECOCA, realmente sentar en la mesa a diversos actores, academia también, por supuesto, para pues seguir empujando, que como mencioné, es un tema que está ya cobrando mayor relevancia. Entonces, estamos trabajando para justamente que se aborde desde diferentes ámbitos y de la mejor forma posible. Muchas gracias.
Gary, anything on the privacy piece?
Sure. The cynic in me would say, good luck. No, I mean, I entendí la pregunta en español, but I'm going to stick to English. Every time you go online, you realize that you are being collected on. We have an entire economy that is evolving, the digital economy that is premised and based on the collection of data and information, right? So that you can be micro-targeted with advertisements and everything else. It's at a scale that is unprecedented, and the trading of that data and information is by and large an unregulated marketplace. That needs attention. But, you know, we also have to distinguish between the activities of governments in collecting information. There are standards, there are laws and rules. They're not equal across all states. They're not equal across all regions. But then between that and the private sector's activities. And again, I just come back to while some of these regimes like the GDPR in Europe and otherwise might have implications for private companies that are engaging in security operations and collecting data and information to inform those operations. They're not regulated to the same degree and in the same way as governments are in providing the same type of service, right? Because they are private actors. And those are gaps that maybe need attention and closing in some circumstances. But, you know, the amount of data that is now accessible is actually, when you start digging into it and seeing, it's pretty jaw-dropping about that kind of information. I'll just give you one anecdote. I used to bring a former operator, a cyber operator, that I had worked with when I was in government. I'd bring him into my class that I teach here on cyber and law. And within a matter of minutes, without violating any laws, he could identify down to the individual person who's the administrator for the networks and systems, understand the operating system it's using, where the vulnerabilities might be in that operating system, so that if he ever wanted to take the next step and conduct some unlawful action against those, he had plenty of an intelligence picture already developed. It's pretty, like I said, jaw-dropping when you look at it.
Thanks, Gary. So again, lack of regulation, private actors. If private security is much more involved in use of technologies and data, collection, then the questions of regulations and risks that go with it. And if you use in former military or former police with that kind of expertise in security companies, then you have a potential for major potential in those security companies to do good as well as bad on those issues. Over to the two of you. I think you both volunteered for at least two of these questions. I think those are questions of accountability in particular. Yeah.
The example that you mentioned is an atrocious example, and the ICOCA has a fuller discussion of it on its website for those of you that are not as familiar with it. But in brief, a lawsuit ensued against the mine operator for the actions of the private security forces. The case was moved to Canada, the home country of the operator. They lost their license to operate the mine, and they had to take their stock price tanked. But the violations against the community were severe, and it really point up the challenges around this power imbalance, which I think is the word you used. I think more broadly, what I would say is that as Rebecca mentioned, under the UN Guiding Principles, Pillar 3 includes remedy both by governments and by companies. It's an expectation that both governments and companies will endeavor to provide effective remedy. What that looks like is going to be different in different circumstances. Here we have grave abuses and loss of life, but it's contemplated that at a minimum, companies will have both some policy in place and some level of due diligence around the hiring of security contractors in the first place, as well as a grievance mechanism for community complaints. So a starting point, and the ICOCA advises on the effectiveness of those mechanisms and provides an additional backstop for these types of complaints. More broadly, the guiding principles expect that home countries and host countries will have effective mechanisms, but it also recognizes the value of operational level mechanisms that could include entities like the ICOCA or the voluntary principles, where they can intermediate, just identify root causes and address them. It's a little bit different than specific remedy for villagers, but to try to improve the regulatory environment that's creating the risk in the first place, professionalize, identify the risk, and engage the actors in a way that is meaningful, so that it isn't simply the villagers working on their own, but it is admittedly an ongoing challenge. Litigation is very challenging in these circumstances, and Pillar 3, the remedy pillar of the UNGPs, is also still underdeveloped. And there are a number of efforts to try to strengthen remedy, especially where national level outlets may be ineffective or unavailable to provide, whether it's through the OAS, through the Inter-American system, through home country litigation, or national contact points maintained through the OECD or otherwise, but to try to broaden and deepen and strengthen those alternative mechanisms.
Maybe just to add one thing to what Meg is saying, I think the guiding principles talk about this need for a smart mix of measures. So both, kind of voluntary measures, but also then obviously regulatory measures that have the teeth to ensure that there's, accountability and enforceability of whatever type of provisions are put in place for regulating the behavior of private security providers. And I think what's really important, particularly for the investor community, is that you see oftentimes this intersection between what I would call enlightened self-interest, because remember, in particular, asset owners, they're taking a long-term perspective, right? They're usually holders of, they're called universal owners. They will hold, across the economy, various companies in various sectors. They're going to hold thousands of companies. So they're not trying to change things necessarily company by company. They want to see overall a particular high standard for companies so that the companies do not themselves, suffer their share prices, for example, their valuation if they commit these types of abuses. And that kind of long-term perspective, you'll actually find embedded in some of the regulations that's coming out of the European Union, where at the core of the regulations is called something called double materiality. And double materiality means that on the one hand, companies need to understand how they're impacting on people, on planet, because those negative impacts can have reverberations where then that also will affect the financial materiality, the value of the company, right? So you see this intersection between kind of financial interest, intersection between financial interest and then also understanding how the company is having an impact on the world around it, right? And so if you look, at what's happened in the European space, you see kind of how these different provisions can come together. So on the one hand, you're going to need good sustainability disclosures. That's what's called the Corporate Sustainability Reporting Directive. You have companies reporting out and putting out information into the marketplace in terms of what kind of effects they're having on the environment, what kind of effects they're having on human rights, social issues, and then also what kind of governance processes they've put in place to address those sufficiently, right? But then why do you need those disclosures? So that investors then can take that data and make sustainable, long-term looking, forward-looking investment decisions that take into account across the market what's happening, understanding that things like climate change are not going to be addressed company by company, right? They're going to be addressed across the various, extractives, but other industries that rely heavily on fossil fuels, right? So again, a longer-term perspective. With that data then, and that data, those disclosures can only come about if companies are doing their due diligence, right? So that's where your Corporate Sustainability Due Diligence Directive comes in place. And then the investors themselves have to report under something that's called the Sustainable Finance Disclosure Regulation. Why is that important? Because then when you're seeking to find a good asset manager to take your assets and invest them well and sustainably, you need to know when they tell you they've got an ESG sustainable investment fund, what that exactly means. What's included in that fund? What kind of data are they basing that fund on? So there's an entire ecosystem you see fitting together in terms of good company disclosures based on good company due diligence taken by investors who themselves are going to disclose what they're labeling sustainable investment, so that all of us, from you, the retail investors that are, holding, your pension funds, to the university and its endowment, that all of these various investors are thinking concertedly about kind of sustainability in a broader perspective. So I think that's just kind of to show how the enlightened self-interest can link up with a very elaborate regulatory framework. Unfortunately, momentarily a bit under attack in the European Union, but we'll see what we can get through.
Thank you, Rebecca. We're quarter past the hour. We have class about 10 minutes for most of us. And I do not want to be held responsible in the face of other professors if you're delayed. So just try to quickly summarize, if I may. And normally, ideally, we could have had 2 hours of broader conversation on this. The 4 speakers made it quite clear that the private security industry is here to stay, and it's going to grow. And in Latin America, the numbers that we're speaking of are in their millions in terms of personnel, and in their tens of thousands potentially in terms of security companies in one form or another. We've identified the fact that there are major regulatory gaps, that there's potential issues in terms of ownership, and there are major risks that go with substandard security companies. But we've also identified the fact that actually good security, well done, well regulated, is beneficial overall, and it's indispensable for many high-risk environments and any environments needing security. The point that you made there, Inés, near the end about the potential inequalities of those who can afford security vis-a-vis those who can't afford private security is a sort of more challenging question to be looked at as well going forward. Noting as well that we can't simply consider private security in isolation, because private security is within supply chains. And therefore, the responsibility of multinational corporations, the responsibilities of the regulators, the responsibilities of the investors, the responsibilities of you also as consumers have to be looked at, because you all have an impact on what security standards could potentially look like, and are looking to manage and mitigate the risk that goes with it. So there's a lot of work still to be done. It's an industry which is also being transformed from the perspective of technology. What does technology offer to the security industry, both in terms of the platforms they can use, but also questions in terms of privacy laws, data management, protection of civil rights, and the likes in different locations. And that conversation is ongoing as well. So we've tried to capture as much of that as possible in 1 hour and 15 minutes. I dare say we could have done a whole seminar on it and spent hours, if not more, to discuss these issues. So could you please join me? A round of applause for our panelists, and thank them again for taking the time over their lunch to brief you on these issues. Please.